this case, the people versus Brandon Belsky for Belsky.
Caitlin Kirby on behalf of the people.
Good afternoon, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Belsky. Your Honor, Mr. Belsky should be, there he is on the screen. Would you please state your name for the record, sir?
Brandon Belsky.
Your Honor, at this time, we'd like to, I know that there is a bond violation. We'd like to address that.
Yes, go ahead.
Your Honor, as you can see from the documentation, Mr. Belsky has appeared for the test, but has been unable to give a sample. He has appeared, from my understanding, each time. He states that this is not the first time that he has had, for lack of a better word, a shy bladder. He states that on a previous occasion where he was required to test, the location was in fact close to where he worked, and he had to go multiple times in order to give them enough urine for a sample. He has requested that he be able to do it orally. He is available to do it orally for you today if you're on that opportunity. As you can kind of see, he's with his son. He's talking to him right now, so he would need some extra time in order to make sure that he's able to get there by the end of the working day. He wouldn't be able to go in the next hour or so. But he is requesting to do that, and that his testing be changed to oral samples.
Well, but hold it. I have missed samples.
He's stating that although they're coded as missed samples, that he in fact appeared. And if you look at one of them, let's see. So he's saying he has not missed, that he has in fact appeared, but he has not been able to provide a sample.
Well,
I had another client who had a similar situation in terms of he was.
Well, I'm not worried about that person, but I've got missed samples. If you look at the difference between what is stated on April 5th, 12th, 20th, 24th, and May 3rd, those are missed samples. On March 28th and May 4th, those are unable or refused. So I don't see those other ones as unable to refuse. I just see this last one as.
And Your Honor, I just double checked with Community Corrections. The missed samples are actually missed samples. The one that says no call, no show, he did not go. There are several missed samples. I just confirmed that if it was unable to refuse, it would have say unable to refuse, just like it does. So he only has for 2 tests, which are on May 4th and May 8th. So the rest are actual missed samples. As to if he has a shy bladder, my concern is that, yes, we're not having any positives for alcohol, but he doesn't have any prescriptions that he's provided to Community Corrections where he would have been positive for THC, buprenorphine, or amphetamines. So I have serious concerns about him missing all of these and then refusing the samples when the last time we actually got a valid sample, it had 3 different kinds of drugs, which we don't have any proof that he has prescriptions of.
You need an amended order. Anything else, Ms. Gaines?
No, I don't believe so, Your Honor. Mr. Belsky, is there anything else?
No, I did miss a couple intakes in between that time, but I talked to a lady there, and she was going to get me into a rehab program, and I went there to talk to them about the rehab program, but they wanted me to drop before I could even talk to them, and I wasn't able to do that.
The case defendant is to get over to community corrections, he's to test today. If he does not test, then I'm not canceling his bench warrant. Okay.
And would it be possible for him to do an oral test as opposed to a urine?
No, he is to drop. I don't believe it that he can't test. He's telling you he can't test, but the problem is those aren't unable to test. They are mistest. He has not tested.
And Your Honor, for the unable/refuse, they allow him to do numerous attempts, and they allow him to stay active.
I understand what they mean.
Yeah, and he walked out.
That's why he's going over today to test.
Thank you.
And then I will set his probable cause out 1 week, June 1st, 2023, 9 a.m. And I'm signing the new order. We're extending it over. You need to test today. Okay.
Thank you, Your Honor.
Okay, Ms. Jones, we'll see you on the 16th.
Thank you.
All right. Take care.
Thanks, JD. Thanks, everybody. Have a good holiday.
Okay, you too, Ms. Jones.
14A District Court for County of Washtenaw, State of Michigan is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning. Apologize about the delay. Court calls the case of Affinity Investment versus Willie Cater.
Good morning, Your Honor. Ron Ruark for Affinity Investment.
Yeah, I took the hamburger up. Yeah. I'm here, Your Honor. Willie Cater. I'm sorry.
Okay, folks, where are we on this case?
This is Mr. Cater's motion, Your Honor, to set aside the order of
The
eviction
conditional order.
on May the 3rd. We're asking the court to deny that motion because he doesn't meet the requirements of MCR 2.612 sub C, and he hasn't made any escrow payments. Your Honor, I don't think Mr. Cater understands that if he pays off the balance, as he said he could by mid-May, that I cannot evict him.
Okay, well, this is, we don't know the legal terms what you're talking about there, but everything was going good with our agreement and with our plans, as you know, until we had depart shortage at Ford Motor Company. Now, I can't be in control for being laid off for the 3 weeks that they laid us off, and I explained everything to you guys, and before this even happened, you guys was getting the payments of 21 to 15, 15, 50 every week without no hitch, working 8 to 12 hours a day. Like I told you.
Okay, all right, Mr. Cater.
Yes, sir.
Mr. Cater, it was
Yes,
not. I read your letter, which I would consider an motion, and it wouldn't be a basis for me to set aside the conditional order dismissal. Let me say this, and what counsel's indicating to you is, can you get the balance paid?
Yes, I can. Yes, I can, Your Honor. I mean, yes, I can. I can have a escrow payment put into y'all Tuesday. That'll be 1 month. I can have another one at the end of that week put in, and that's $4,000.
Okay, but
like I was doing, Your Honor, before even we got laid off, I was making my payments without a hitch. 2,100 the first week, 1,500 the weeks after that, and that was all just then.
This is the second time you're telling me that. I heard you the first time.
Oh, I'm sorry.
Your Honor, we ask that the court re-enter the order of eviction if he wants the 3 days. In addition to that, after the posting, we're fine with that. The balance right now is over $11,000.
The balance is not $11,000. I don't understand where you're getting your numbers from. I really don't know where you guys getting your numbers from, because on our agreement, we had everything set in stone with a balance to be paid off by the end of April. So it's only May, and that was only $6,000 and some owed. You understand? So I don't understand how another $5,000.
Sir, Mr. Cater.
Yes, sir.
Please. On the conditional order of dismissal, there was a total amount that needed to be paid
Mm-hmm.
of $12,780.
Yes, sir.
How much of that amount has been paid?
Over $6,000 and some. And that was every weekend, and he can verify this. I paid the first payment of $2,100. Then I made the next 3 payments of $1,500.
Mr. Cater, I asked a question that required a number, not a long explanation.
Well, I paid over $6,000 on the 12, Your Honor. Or in that range.
Counsel, would you agree with that?
I know he made extensive payments. I do have my client here with me. She can confirm, but keep in mind, Your Honor, March, April, May rent has all become due.
Okay, so you know what? If neither one of you are going to answer my question, just keep talking. I'm going to go on to somebody else because I'm not going to deal with this. I got a lot of people I got to deal with today.
My client is here, Your Honor. She can confirm what payments have been made. Her name is Suri Huang, and she's in the Zoom conference.
Of the $12,780, how much has been paid? There should just come a number to me.
I don't see my client, so I'm going to agree with Mr. Cater. The number that he said, I think it was $6,000. I'll agree with that.
Okay. So if I say that, if that's true, then there's $6,780 that needs to be paid on the conditional order of dismissal. There may be other monies that are owed, but I'm just looking at the conditional order of dismissal.
Understood.
Yes, sir.
So when do you have that 6,780, Mr. Cater?
I have on hand. I have $2,000 in some of that, Your Honor. On hand as of now.
Okay. So when would the other 4,780 be paid?
I can have the other 4 some paid by, I'll say, May the 15th, May the 16th, with no problem at all. I'm back
Of the
at
16th
work.
of, you can have it paid by the 16th of June?
Yes, yes, sir. Yes, sir. Yes, I can.
Mr. Rourke's client can't get her audio to work, but she did post in the chat that Mr. Cater paid $5,900.
Okay. Okay. Your client could not get her audio to work, but it's right around that same figure she says $5,900 was paid. So it's right around the 6.
I understand.
All right. And so how much is now owing on this? I mean, that would bring us current through April, and then there's going to have to be May and June paid, right?
That is correct, Your Honor.
All right. Here's what I'm going to do. You need to pay to the landlord, sir.
Okay.
And I'm going to go with their number. So I think you gave me an even 6. She says 5,900, but you're going to need to pay to the landlord. I just need to add an extra 100 to that, right? So $6,880.
Okay.
The plaintiff again, $5,900 remains unpaid.
Oh, 5,900 remains unpaid.
Both paid that amount, and that is the remaining amount unpaid.
Okay, so he paid half. Okay, so they're indicating that 5,900. Your client is indicating 5,900 is owing. So you need to pay to the landlord $5,900.
Yes, sir.
You need to pay that by June 16th.
Yes, sir.
Well, June 15th. I want it paid by the 15th.
Yes, sir.
2023. Then we'll deal with May and April.
Yes, sir.
May and June.
Yes, sir.
But, sir, be prepared that what the court may order on that date so that you understand is that whatever is due, I'm not saying I'm ordering it now, but whatever would be due for May and June may be due before the end of the month in June.
Yes, sir. No problem.
I will then adjourn this. Yes.
So sorry. His client indicated she misspoke. $6,800 is the remaining.
Okay, so now your client is indicating they misspoke. So what I was saying before was the 6.8. So here's what's going to need to be paid: $6,800. That's the last figure I'm giving.
Yes,
Needs
sir.
to be paid by June 15, 2023. We'll then deal with May and June. If you don't pay that, I'm going to sign the writ.
Yes, sir.
I'll adjourn this matter out to June 16, 2023 at what time? At 9 a.m. Thank you.
Yes, sir. Thank you.
Thanks, Your Honor.
Court calls the case, People versus Brittany Dallas.
Caitlin Kirby on behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Dallas. Could you please unmute and state your name for the record?
Brittany Dallas.
Thank you. Your Honor, I did speak with the prosecutor, and the prosecutor will agree with allowing Ms. Dallas to plead to the lower OWI charge as opposed to the high BAC count. And she would like to avail herself of that offer.
So she's going to plead to an operating while intoxicated.
Correct.
Dallas, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Brittany Dallas.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. That is a misdemeanor punishable by up to 93 days in jail, up to a $500 fine plus court costs. Court could also order any rehabilitative services or community service the court deems necessary. You understand that?
Yes, Your Honor.
You understand also that the court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself, or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
March 17, 2022, at the location of 5511 West Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor.
What did you have and how much?
I went out and drank with friends at their house. I was also door dashing before I headed out there. I was door dashing in the area. So when I got tipsy, I decided to stop at their house to have a few drinks with them. So we had a pint of Jack Daniels between 3 people.
Okay. Were you stopped by the police or was there an accident?
I actually fell asleep behind the wheel at the gas station with my running.
Okay, so you fell asleep behind the wheel. Did the police arrive?
Yes.
All right. Were you ultimately arrested?
I was under arrest while I was under emergency care.
Okay, so they called an ambulance.
Yes, Your Honor.
Okay, were you taken to the hospital?
Yes, Your Honor.
All right, was there a blood draw?
I can't remember that, Your Honor. It was so long ago.
All right, but so at some point they drew your blood while at the hospital while treating you, did they?
They must have had, if you guys like the blood alcohol content.
Okay, so you're not disputing that they drew your blood?
No.
All right. And do you know what the results of the blood test were?
No, not, Your Honor.
All right. Counsel, will you stipulate for purposes of the plea that it was a .23, I think it was?
Yes, Your Honor.
Yes.
Ma'am, do you have any reason to dispute the blood test results?
I don't even know how to answer that. I mean, if that's what they say my blood alcohol content was, I have no choice but to believe them.
Well, you always have a choice. I'm saying, do you have a reason why you would believe that those blood test results are inaccurate?
No, Your Honor.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be March 15, 2023, 9 a.m. as your Zoom invite indicates. All right, Ms. Dallas, I need you to stay on the line there. We're going to put you into a breakout room with probation intake. They'll get some information from you, give you information so we can proceed to sentencing on time, okay?
Okay, thank you, Your Honor.
Thank you.
Court is still in a brief recess. Mr. Jawand Richards, you are in court. You cannot be smoking a blunt.
Damn.
I don't know if that nigga's slow or that nigga's slow.
Excuse me. The 14A District Court for County of Washtenaw, State of Michigan is now back in session. All those having business before the court draw near. The Honorable J. Cedric Simpson presiding.
The individual that's labeled iPhone 5, what is your name? iPhone 6, excuse me. What is your name? iPhone 6, identify yourself. iPhone 6, I know that you're hearing me. If you don't identify yourself, I'm kicking you out. You won't be in, and you're going to end up with a bench warrant because I'm not going to have that language in my courtroom. Kick him out.
that was me. I'm sorry.
What is your name?
Gregory Ross.
Sir, this is a courtroom, although it be virtual. You will not use that language. You will not use that language ever in my courtroom. Am I understood?
Yes, sir.